whole process was the political process. That's what Salve argued, council argued. This is a political compromise. So you pull the plug anytime you want to pull the plug. At least 370 doesn't allow you to do that, but assume that's the case. If it's a political compromise, there will be a political solution. Why are lordships finding some constitutional solution that doesn't fit into this? That's not what your law, you have to, please look at it this way, Malad. If the process was political, the solution has to be political. Now, how that solution comes about is not neither for your lordships, not for us to suggest. This is something that they have to do in collaboration.
The initial part was political, now it has to be constitutional.
No, Malad, if that is so, Malad, if now it's constitutional, then that means that the
While
Constituent
keeping in
Assembly,
mind,
just look at it this way.
the fact that the intent behind the article was temporary and transitory.
Well, that I'll come to a little later, but Malad, the answer to the question is that the Constituent Assembly was framing the constitution of Jammu and Kashmir, knew that after that task was over, it would end, and was signing a death warrant under 370 sub-article 3 that now you can abrogate the constitution. Well, that can't, I'm sorry, Malad, on a plain reading of 370, I have the greatest respect for your lordship.
Therefore, the sequitur of your submission on the proviso to clause 3 is that once the Constituent Assembly has formulated the constitution of J&K, which has been adopted,
Yes.
the proviso ceases to have any existence.
Yes, and 370 ceases to have effect.
Therefore, 370.
370 ceases to have effect. 3 ceases to have effect.
Sorry, 370 or
Sub-article 3 ceases to have.
Therefore, 370
Yes.
bracket 3 ceases to have effect.
Yes.
In which case, 370 by itself, apart from 370 clause 3, assumes a permanent character.
It's permanent in the sense that, Malad, what is left of this autonomy that we are talking about? If the argument is it is just a shell, what is it that you're trying to do? What is the argument today, Malad? I've heard it, Malad, several times over. What is left is only a shell. Everything is already there.
That there is a contradiction in their argument.
Well, I'm only saying, Malad.
Just one. Yeah. There's a contradiction in the argument. They said that main substantial part of the constitution, including 356, is now fully applicable. But what was the main stumbling block was section 6 and 35.
As far as 35 is concerned, that's a separate issue.
No, I'm not interpreting complete adoption of the Indian constitution in toto, in completely, as in case of other states.
Strike down 35A. Well, I don't understand where we are getting here. If this is the only stumbling block, you strike down 35A.
That's the judicial way.
No, that can't be politically done in any case. Because there can be reasonable restrictions and there can be classifications in terms of Article 14. It has happened in Uttarakhand, it has happened in Himachal, it has happened in other states, Malaj. It can't happen in Kashmir. Malaj, it is happening in Assam. You are fixing a date to people who came into Assam.
We come to that little later.
Malaj, I'm only trying to, Malaj, indicate, show the mirror to myself that if it happens in Kashmir.
There's actually, I feel, the two spectrums which have to be decided.
Yeah.
When you use the word temporary, whether it's actually temporary in the sense they understand it, or it is temporary in the sense you understand it, that it was with the context of the Constituent Assembly, one. Number two, how you understand subclause 3 is that once the Constituent Assembly dissolves itself, 370 in the form it exists according to you is frozen in time for all times to come. Correct? This is what your argument is.
No, 370 sub-article 3, Malaj. The rest of it is still remaining.
Yes, I'm saying 370, the remaining part is frozen as period of time because of the historical perspective.
No, not remaining, Malaj. You can continue to integrate. 3 is frozen.
3 goes to the remaining part subsidy.
Yeah, absolutely.
They say no, 373 is not limited to that stage because of the manner COs have been issued and can extinguish themselves.
That COs have been issued not in under 3.
Then comes the methodology, whether they could have done it or not.
Well, the COs have not been issued under 3. This is the problem, Malaj. These COs can continue to be issued. All of them are under 1. So, and Malaj, I'm sorry to say this, when you talk of temporary provisions, it is not a temporary provision.
Mr. Sibal, ultimately, therefore, it will boil down to this, that there is in our constitution, if we accept your submission, there is in our constitution a provision to which even the amending power, which is available in respect of the rest of the constitution, is unavailable.
It's unavailable because it's been amended. 368 has been amended with a proviso.
And there is, in that sense, a provision of the constitution which lies even above the basic structure of the constitution.
No, Malaj, I mean, why do your
Because you
lordship say
cannot,
this is...
370 you can't amend also.
I'm sorry.
You can't amend 370 also.
It's not
To amend 370, you have to take the route of 368, and 368 takes you back to 371 by the proviso. Therefore, we would be then really accepting a situation. We're not saying it's unstateable. We're testing the proposition. Is there a part of the Constitution? The only restriction we have found so far in our jurisprudence on the power of altering the Constitution is the basic feature doctrine. We are now going to add one more, which is that Article 370 lay even beyond Article 368, and much beyond the basic structure doctrine, because you can't touch Article 370. It assumes a character of permanence.
Well, this is getting more interesting. This is even getting more interesting. Malaj, let me now ask myself a question. Supposing I were to file a petition tomorrow in this court that the proviso to 368 is unconstitutional. 368 too. Supposing I were to file the petition, and what my lord is saying is upheld, is right. That how can you do that? Strike down the proviso to 368 and amend it under 368. There are hundreds of ways of doing the same thing, Malaj, but we are testing the proposition in the context of what they have done.
The postulate that in the exercise of judicial review,
but your lordships are putting to me.
We must take the proviso as a given.
But I am saying, yes, Malaj, it's your lordships who are saying there's something silent in it, which I don't see, Malaj. I don't see the silence in that proviso where the perpetuity of a presidential notification can be issued at any time, even after Malaj, even...
Because the two plain consequences of your submission are, first, once 370 clause 3 goes out of operation for all intents and purposes, 371 and 2 have a permanent character in the Constitution.
2 is not there, Malaj. 2 is not there.
Right, 2 is, of course, yes, after the Constitution. Yes. 371 has a permanent character in the Constitution. Correct. Second, you cannot amend 370 using the 368 power because of the restraint which is imposed by the proviso, which again takes you back to 370. Therefore, even the power to amend 370 is within the fold of 370 and not 360.
Let me answer that also straight away, Malaj.
So we are carving out really a provision of the Constitution which lies even higher than the basic features doctrine.
No, Malaj. That your lordship should not say, Malaj, because that's not yet tested. That your lordship should not say, that's not tested yet, whether it's higher than the basic feature of the Constitution or not, Malaj. But kindly see, this was added in the 1954 order, Malaj. The proviso to 368(2) was brought in by the order, as well as, Malaj, the proviso to Article 3 in 1954. Who brought it, Malaj? The government of India. State of Jammu and Kashmir did not. They gave its consent to it. Why did they do it? Because they did not want 370 to be tampered with. I'm not saying this, Malaj. I am talking of the intent of the government of India. And the proviso was added both to 3 and 368. Not my intent. And your lordships are now saying, what is the intent of the government of India? It was made clear that even under 368, you can't do this. Government is a continuum. Kindly, Malaj, appreciate that. It is not something that was done by Jammu and Kashmir on their own. I understand, Malaj, and there we go into the sentiment argument, the emotive argument. The argument that Mr. Dwivedi made, with respect. That we appreciate the sentiments of people of Jammu and Kashmir, but there are sentiments in India. Malaj, with the greatest respect, I humbly pray that we are dealing with the Constitution. It's a sentimental thing. I also have sentiments with a lot of things. But when we come to court, we discard do away with what what our heart, the nature of our heartbeat, and come to brass tacks and interpret the Constitution. You can pepper it with emotive instincts, but you can't get away from the plain language. And my respectful summation to your lordships is a political process must have a political solution. And as I said, what is left of 370? There is no residuary power with we talk about residuary. What is the residuary power? There's no residuary power with the state. When did the state ever exercise residuary power? So for all intents and purposes, it is fully integrated.
In other words, according to you, there is no solution to Kashmir
No.
within the Constitution. Devise a
No,
solution outside the Constitution.
now your lordships are putting this to me.
Ultimately, that's
No,
your,
no, no,
that's
that's
your,
not what I've argued.
that's the hypothesis, that the solution has to be political outside the Constitution.
It is a problem looking for a solution, and your lordships don't have to provide that solution, is what I'm saying.
All solutions have to be within the framework of a Constitution.
It is within the framework, Mothers. It is within the, who says it's not within the framework?
What is